That's okay. So kind of a follow-up question. So I just opened this fund, and the fund is a limited partnership. It was created, the limited partnership is Delaware. The limited partners are from all over the place. So if there's a limited partner within that partnership with New York residency, does that exclude us?
Not if it's a New York, if any of the owners of the, so again, think of it as a family tree. You're looking for second, third, and fourth cousins.
Yeah.
If any of those second, third, and fourth, fifth, and sixth cousins, twice removed, three times removed, if anybody is considered a New York citizen, then you're going to be, you're not going to be able to get into federal court.
Wow.
So we have to do the family tree. We had a very large Wall Street hedge fund find out that the hard way. They set up, there was a one New York citizen 7 generations removed from the LLC that owned the note, and that was enough to get us thrown out.
Wow.
Yeah, so the answer is you have this, these are the things that we have to examine, because we have to make a certification as the attorneys when we file the papers that the case is that we've met the diversity test.
Okay.
And you don't want to run afoul of that, because if you've blundered that and you come back into court another time with a qualifying LLC, you don't want to have a black eye in federal court. It doesn't do you well.
A lot. With that said, though, what are the typical, processes that are quicker? Is it the fact that the defendant can't get an attorney who knows it? Is it the fact that the judge is very strict on the timelines? Besides not being able to kick the can in the curb, what are some of the things that make it faster?
Well, first, there in New York, for residential mortgages, there's typically a mandatory mediation process, or as I like to call it, let's string this out for another year. And especially with what's going on now in the busy courts, it's going to be the better part of a year just to go through the mediation process. So you're already a year behind. Then you start the actual foreclosure process. There are motions, all sorts of ways to delay, and the judges, frankly, are overwhelmed. The clerks are overwhelmed. You take the mediation process out of the dynamic, and you've already shaved a year. In the current world, you shaved the better part of a year off of the timelines. You also take away the nonsense motions and the post judgment order to show cause, or 2 or 3 or 4 or 5, and you've eliminated that. It's also very easy to file an appeal in state court. It's very, very easy. It's not quite as easy to file that same appeal in federal court, or to process the appeal process properly. We've seen in state court where we win the case, we get our judgment, and the borrower walks across the street to state appeals court. There's a pro se part in there. The clerk helps them fill out the form. 1 page, you waive the fee because they're poor, and that's it. Now we're back to the beginning. The case is stopped pending the appeal.
Mm-hmm.
It's more difficult to do that in federal court.
Okay.
But the most significant factor is that in federal court, as opposed to most state court judges, the judges in federal court do control the timelines, and they monitor it brutally carefully. It's with great precision, and it's a different process. And then when we get to the sales, it's also a little bit more dignified too.
So could you? I mean, I know you're in New York. Is this something that could be done in Texas and Florida, or are the rules different? Or
well, the answer is the first question would be: is it worthwhile to do this in another state? If you're in a non-judicial state, there's no sense in going into court in the first place. If you're in a judicial state, then it depends upon the timelines, because some judicial states get you in and out in under a year. So federal court isn't going to make sense. But in the notoriously slow states, for example, New Jersey, New York, I think Massachusetts is also a little bit lumbering. If you can access the federal courts, then that's something to consider. And I would urge you to check with local counsel who handles foreclosures in both state and federal court. In New York, most of the firms that handle foreclosures don't handle federal court, simply because the staffing issue, and they can't use appearance counsel, and also their clients won't qualify for federal court. Either the banks or the Fannie, Freddie, agencies like that aren't going to qualify. So it's of necessity, you need to check with the firm and find out who does the largest volume in that state, the people who are there in that federal court every day, or who are a brand name and a known entity to the judges and the clerks. It makes a difference.
Interesting. So if you've got, you mentioned like the judge keeps a very rigid timeline on that. I'm going to infer that then you can't just go with any attorney because if they're already overworked and overloaded with whatever else they're doing in the state courts, it'd be very easy to miss one of these deadlines.
It's not only easy to miss it, you have to know who you're in front of. And each judge has his or her own peccadillos, and each judge has his or her own rules. And federal court isn't the place to learn how to practice law, learn how to practice foreclosure law, especially. And if you're a good state court attorney, that's where you belong, in my opinion, because you practice what you do best, practice it where you do best. We don't go into like the patent and trademark court. We're not patent and trademark attorneys. We're not admiralty attorneys. So if your boat gets hit by somebody else's boat, please don't call me. We can't help you, because that's not the area of law that we practice. And the same, it should be no different. You don't call your obstetrician when you break your leg. You call an orthopedist. And
Right.
they're the same way that doctors limit their practice or specialize in certain areas. So too, we have a team. I've got 3 people on this call who do nothing but federal court.
Yeah.
And it makes a difference in the outcome.
That's fascinating. So I've heard about this years ago, and it just because kind of like this fabled unicorn, this federal court idea. Are people not doing it just because it's unknown, or they are not qualified?
Well, here's one answer we got from a hedge fund. They were afraid of bad publicity for pursuing the foreclosures too quickly. My response to that was, because you foreclose so slowly, you get good publicity. And the answer obviously is no. And by the way, they ended up using us. They sent a portion. It was something that hadn't occurred to in-house counsel. And I remember the discussion, like, wow, we never thought of it that way. So, but it's the percentage of files that do end up in federal court is teeny, because once you remove Fannie, Freddie, Bank of America, Citi, Chase, Wells, all the big ones, you've taken 98% of the loans out of the potential pool for these foreclosures. So the other several percent that's left are what we're talking about.
Is there a difference in the auction and redemption periods and whatnot? Is that all similar process?
We don't have a redemption period in New York. That's one way of slowing down the process that hasn't happened yet in New York. But the auction process is similar. The whole process, the whole federal court foreclosure process parallels the state court process, except for the mediation. There's no mediation. If you want mediation, if you're foreclosing with the intent of getting the loan back on track or modifying it with the borrower, it's a good way of putting pressure on the borrower. Because I can tell you from personal experience, when you open up the mail and there's a summons from federal court, your day is not getting any better. It's you're off having been sued. There was a time, by the way, for whatever it's worth, that we kept track that my partner and I had more RICO cases against us than John Gotti. That was a tool that the defendants were using at a time to try to stop the foreclosures. They would lose the foreclosure, and then they would turn around and go back into federal court, sue the bank, the title company, all the attorneys. One of them sued the judges. We had a case where the judges were sued personally, claiming that it was that we all conspired, and it was RICO, the Racketeer Influence Corrupt Organization Act. Yeah, so I had a bunch of them. But you can use the foreclosure process, especially federal court foreclosure, because it's so ominous, as a tool to negotiate with your borrower for a modification or to get back some way to get back on track. And many of our clients do that. You don't want to take anybody's house away. That's not what this is about. This is about there's a loan, they signed a contract to make payments. It's about getting everybody back on board again and back in compliance.
So typically when we're gonna file foreclosure, I'm gonna send my demand letter and it's almost quick. It's automated, right? Get the demand letter sent out, my attorneys get files, start the process. Through federal court, this check and balance is how long should we expect a delay to review and make sure that it can be deemed appropriate for federal court?
It depends upon what you send us. When we had to review trustee and pooling agreements that were 500-600 pages, well, it's going to take longer than if you're a one-man LLC. And I've just got to do some basic checks on you individually and see where the LLC is set up. That's moments. But the trustee and pooling agreement was several hours.
Gotcha.
So
So it sounds to me as that this for us as individual investors, LLCs, maybe what partner to, this is probably the same period of time as a normal state foreclosure process to get initiated started, send the demand letter out.
Yeah.
They get a letter from the federal system versus the state. Most of the time, the borrower doesn't do any different until they try to reach out to an attorney. And attorney says, whoa, that's a different level. I can or can't do it, or I'd rather not. It probably scares a lot of borrower attorneys, defense attorneys, to walk away from it, would it not?
it does. Well, we don't know who, we obviously would never know who said no to taking on the case. We only know who says yes to taking on the case. But I can tell you that a lot of the attorneys with the billboards don't appear in federal court because they make their money. In order to pay for these billboards on the throughways, you have to have a lot of files coming in. This isn't a personal injury case that you settle for $10 million. These are people who are paying you hundreds of dollars or several $1,000s. So you need a lot of them, and you can't do volume in federal court for the same reason that I said the attorney who signs the complaint is the attorney who's on the file. So in a state court, you can have anybody appear on behalf of the firm.
What happens if I own a note, I start federal court, and I sell to Nathan?